Hi, I'm Angela Price-Stevens. In the article associated with this video clip, I look at the court's discretion permitted by the Wills, Estate and Succession Act to make good or fix an otherwise defective will. As I'm sure you are aware, there are certain formalities required to make a valid will. Where the document fails to comply with perhaps one or more of these formalities, the court may use its discretion to determine whether the deceased's intentions, as set out in the document, were deliberate and fixed and a final expression of their intention for the distribution of their property on their death. Now, this may sound like an odd choice of words or an awkward expression, but these are the words used by the court in its assessment to distinguish between what the deceased meant to be used as a final will or simply instructions for a draft of a will, which may of course be later changed on review. The court is anxious to ensure whether the document, which may be a will, was actually intended to be used as such by the deceased. The article, Is It a Will?, sets out the requirements to make a valid will and looks at two cases where the courts had the opportunity to review the use of its discretion under Section 58 of the Act. If you are faced with a document that looks like a will but does not quite meet all of the criteria, it is wise to seek legal advice and possibly direction of the court before reliance is made on the will, or a decision is made to ignore the document and distribute according to the rules of intestacy, as if there was no will at all. Of course, it is always important to check for any prior wills. If the will-like document were to fail, the previously dated will may take effect. If you wish to challenge a will based on its validity, you're welcome to give me a call or contact me through my website.